Welcome to this AI debate on Trump's January 2026 Maduro capture, legal justice or illegal invasion, where chatbots explore both sides. We'll begin with opening statements from legal justice and illegal invasion. Now, legal justice.
Imagine a situation where an accused head of state is credibly linked to narcotics shipments that threaten lives in multiple countries. Would leaving them unchecked be justice or complicity? I argue the Maduro capture was a lawful and necessary exercise of state power, consistent with both international and domestic legal doctrines, and that it advanced accountability without abandoning long-standing legal limits. First, international law does not categorically ban extraterritorial uses of force. Article 51 of the UN Charter preserves the right of self-defense when an armed attack occurs or is imminent, and the customary law that underpins that clause, reflected in classic state practice, permits a measured response when lives are at stake. The International Court of Justice has made clear that the existence of a real and attributable threat matters in judging necessity and proportionality, not an abstract respect for territorial borders alone. Those principles trace to the Caroline Doctrine and its modern descendants, which require both immediacy and strict proportionality before cross-border force can be justified. Second, the specific facts at issue matter. Credible evidence linking a sitting leader to transnational narcotics networks and to attacks on regional security can amount to an imminent, attributable threat to U.S. persons and interests and to regional stability, satisfying the necessity threshold and allowing a defensive response narrowly tailored to the threat. Where intelligence shows ongoing shipments and imminent harm, inaction risks complicity by omission and permits continued loss of life. Action, by contrast, can neutralize the danger and create space for lawful process. Third, consent by a legitimate domestic authority converts an otherwise unlawful intrusion into a lawful operation when that consenting entity actually possesses the authority to decide law enforcement cooperation for the territory concerned. When a recognized interim government or an empowered national institution invites foreign assistance to arrest a criminal suspect, that consent removes the territorial integrity objection and aligns the action with cooperative law enforcement practice under mutual legal assistance frameworks. Fourth, international criminal law and treaty regimes provide concrete avenues for accountability. The Rome Statute and analogous instruments recognize that certain offenses, war crimes, crimes against humanity, and organized transnational criminal conduct, do not disappear behind immunity claims where state actors use their office to commit or facilitate international crimes. Mechanisms like universal jurisdiction and international criminal forums exist precisely to prevent impunity for cross-border harms. At the same time, narcotics conventions and UN instruments governing illicit trafficking create reciprocal obligations for states to cooperate in investigation, extradition, and disruption of trafficking networks. Fifth, domestic law supplies the executive branch with authority to act in defense of the nation while binding it to constitutional constraints. Article 2 gives the President significant commander-in-chief responsibilities to protect U.S. nationals and interests abroad, and authoritative legal analyses have long described circumstances in which the executive may use force extraterritorially to prevent imminent harm. Those powers are not unlimited. They must be exercised in light of necessity, proportionality, and respect for detention procedures, including prompt access to counsel and fair trial guarantees. To meet criminal justice norms, any detention arising from such an operation should secure Miranda protections where applicable, permit counsel and consular access, and ensure that prosecution proceeds before competent tribunals. Sixth, historical practice supplies parallels that make this operation intelligible within existing state behavior. The international community has seen leaders removed and criminally processed when they faced credible allegations of severe transnational wrongdoing, and states have previously conducted focused operations, always controversial but legally analyzed and often accepted as legitimate when grounded in self-defense, consent, or clear enforcement authority. Seventh, predictable objections must be answered. Concerns about sovereignty are real, but sovereignty is not a shield for criminal enterprises. Where a state actor is engaged in crimes that harm others, or where a legitimate domestic authority invites assistance, territorial sovereignty yields to the imperative to stop ongoing international wrongs. Worries about Security Council authorization are legitimate too, but not dispositive. The Charter itself contemplates self-defense as an exception, and modern state practice recognizes exceptions when waiting for Council action would allow irreversible harm. Finally, slippery slope arguments forget that law constrains action through hard tests: necessity, immediacy, proportionality, and subsequent judicial oversight, not by blanket prohibitions. When these tests are strictly applied, when evidence is transparent enough to survive independent scrutiny, and when suspects receive due process in competent forums, an operation to capture an alleged transnational criminal leader is not lawless adventurism, but a calibrated instrument of justice.
Now, illegal invasion.
Picture a Caracas neighborhood in January 2026. Families woken by the thump of helicopters, lights strobed across apartment blocks, and armed personnel moving through streets. Not because Venezuela had launched an attack, but because a foreign operation decided to seize a sitting head of state. That image captures why legal limits on the use of force are not abstract niceties, but the guardrails that prevent chaos in international life. The central legal point is simple and decisive. The UN Charter bars the use of force between states except where the Security Council authorizes it or where a state acts in lawful self-defense. Neither exception was met here. There was no Security Council mandate authorizing the seizure, and the facts presented do not meet the stringent tests that Article 51 and customary international law require for anticipatory or emergency self-defense. The International Court of Justice has made clear that unilateral coercive military action across borders, absent those narrow exceptions, violates the prohibition on the use of force and attracts state responsibility. That jurisprudence is reinforced by the broader principle of non-intervention and the doctrine that states must respect each other's territorial integrity and political independence. Claims that this seizure was lawful because it targeted alleged criminal conduct or because it served a broader policy objective miss the point. International law does not license cross-border abductions simply because one state regards the target as a criminal or a threat. Criminal allegations must be resolved through lawful channels: arrest, indictment, extradition, or international adjudication, not by military grab operations that bypass established procedures. For decades, states have condemned extraterritorial coercive seizures because they substitute force for law and invite reciprocal conduct. Even where domestic courts have sometimes allowed evidence obtained after forcible capture to be used, the international consequences, diplomatic rupture, claims of state responsibility, and erosion of norms are grave and predictable. Domestically, this operation raises an equally acute constitutional question. The executive does not have unfettered authority to undertake forcible captures abroad when Congress has neither declared war nor provided a specific authorization for the use of force. The Supreme Court's framework for executive power in foreign affairs emphasizes that the president's authority is at its lowest ebb when he acts contrary to congressional intent, and unilateral military operations without statutory backing risk breaching that line. The War Powers Resolution likewise channels the constitutional balance toward consultation and congressional oversight when U.S. forces undertake hostilities or sustained military operations. Those domestic constraints exist not to handicap the executive in urgent cases, but to ensure democratic accountability and legality. Proponents will predictably argue that the seizure was justified as self-defense or as an emergency measure to prevent imminent harm. That argument founders on law and fact. International law's necessity and immediacy requirements demand clear evidence of an imminent armed attack and the absence of any practical, lawful alternative. Speculative or long-term threats do not satisfy those thresholds. The public record does not show the kind of contemporaneous, demonstrable threat that would permit a forcible extraterritorial abduction to be recast as lawful self-defense. Nor can a claim of consent rescue the operation. Consent must come from a legitimate government authority with the competence to bind the state, and contested claims about proxy or manufactured consent cannot retroactively validate the use of force. Beyond legality, the policy consequences are stark. A precedent that allows states to kidnap foreign leaders by force invites reciprocal acts, accelerates regional instability, and risks civilian harm when military operations are conducted in densely populated urban areas. The normative cost is especially high for a state that claims to champion the rules-based order. Endorsing such seizures undermines U.S. moral authority and arms other regimes with a justification for mirror conduct. The proper course is clear and lawful. Pursue remedies through international and domestic institutions. Seek clarification and relief through the International Court of Justice. Engage the UN and regional bodies diplomatically. Rely on extradition and mutual legal assistance where appropriate, and subject the operation to rigorous congressional oversight and possible inquiry. Those paths preserve accountability without tearing down the legal architecture that restrains interstate violence. To accept unilateral forcible seizure as lawful is to invite a world where might repeatedly makes right. Defending the rule of law in international affairs means insisting in January 2026 and beyond that even when a leader is accused of grave wrongdoing, states must act within legal limits through extradition, international courts, or Security Council processes, rather than by rewriting the rules through forceful abduction that violates both international obligations and domestic constraints.
Now, let's hear the first rebuttals from legal justice and illegal invasion. Now, legal justice.
That image of helicopters over Caracas is powerful, and I won't downplay how alarming it feels. But the question before us is not the drama of the scene. It's whether a narrowly tailored operation to prevent imminent transnational harm can ever be lawful and just. The capture at issue must be judged against three firm legal anchors. First, international law recognizes limited extraterritorial force in self-defense when a clear, imminent threat to nationals or essential interests can be traced to state-enabled criminal networks. Necessity and proportionality constrain that response and require the least intrusive effective means. Second, valid consent from a legitimately empowered Venezuelan authority, for example, an interim government or authorized officials, can lawfully permit foreign forces to act on Venezuelan territory. Consent turns what would be an intervention into cooperative law enforcement. Third, long-standing criminal justice doctrines, extradition agreements, universal jurisdiction for certain international crimes, and multilateral narcotics instruments create cooperative pathways for arrest and transfer when transnational crimes threaten lives across borders. If extradition is impossible and credible intelligence shows imminent shipments that will kill, narrowly targeted capture may be the only practical way to stop the harm while preserving evidence for prosecution. Opponents say sovereignty is absolute. I say sovereignty is not immunity from accountability when a leader uses state power to enable international crimes. Immunity doctrines protect official acts, but they do not shield conduct that traffics in narcotics, terrorism, or crimes against humanity. Allowing territorial integrity to become a safe harbor for transnational killers would pervert the rule of law. They also point to the Security Council. The Council is central, but its primacy does not erase recognized exceptions. Self-defense and consent exist because delay can mean deaths. Domestic constraints matter too. The President's Commander-in-Chief authority permits defensive action, but lawful operations must be paired with prompt congressional notification, independent judicial process, and full criminal procedure safeguards on arrival. Access to counsel, fair trial, and transparent prosecution. Fear of a slippery slope is real, so the operation must be tightly circumscribed. Precise objectives, minimal force, rapid handover to courts, and independent review. That is the distinction between lawless abduction and accountable enforcement. If credible, time-sensitive intelligence shows a leader is directing shipments that will kill innocents abroad, what does justice require? Waiting months for diplomacy while lives are lost, or a carefully limited capture that preserves evidence, disrupts criminal networks, protects citizens, and places the accused before an impartial tribunal? The answer lies in constrained, proportionate enforcement that turns accusation into adjudication rather than impunity into safe haven.
Now, illegal invasion.
This debate isn't about whether we like the outcome, It's about whether a state may bypass the legal rules that keep interstate violence in check. The UN Charter's basic architecture forbids the use of force between states except where the Security Council authorizes it or where a state acts in lawful self-defense. That framework exists precisely to prevent powerful states from treating their law enforcement preferences as a license for cross-border seizures. My opponent leans on self-defense, consent, and executive prerogative, each tempting in rhetoric, but each collapsing under legal tests that the Charter and long-standing state practice require. Start with self-defense. International law requires an actual or truly imminent armed attack and a demonstrable showing that there were no practicable alternatives. Allegations of long-running criminality or future illicit shipments do not satisfy the immediacy and necessity tests. If imminent armed attack were the standard for every transnational crime, any accusation could justify unilateral force. That would dissolve the rule against the use of force. Second, the idea that some domestic actors' consent cures illegality is hollow when the person seized is the sitting head of state, and when the domestic authority claiming to consent lacks clear legal competence. Consent must be genuine, given by a government that actually controls territory and is recognized for that purpose. Contested or proxy approvals cannot lawfully convert an invasion into a lawful arrest. Third, on domestic law, the president's duty to protect nationals does not erase separation of powers constraints or statutory limits. The war powers framework and long-standing practice require either Congress's clear authorization or a narrowly confined, truly emergent defensive response. Skipping extradition and mutual legal assistance channels turns diplomacy and legal process into afterthoughts, undermining the rule of law and creating grave constitutional exposure. My opponent argues necessity and proportionality were met, but they offer no contemporaneous evidence showing alternatives were exhausted, no documented intelligence supporting an imminent armed attack, and no public legal authorization that would make the operation legitimate. The practical costs are severe. Destabilizing a fragile country, risking civilian harm, incentivizing reciprocal abductions by rivals, and eroding the norms that protect small states from big power coercion. Those are not abstract harms. They are predictable consequences of normalizing extraterritorial seizures. The only responsible path is to insist on lawful channels, pursue extradition and mutual legal assistance, pursue remedies and accountability through international courts and the UN system, and subject any executive action to prompt congressional and judicial review. If accountability matters, it must be pursued within the law, not by violating the very rules that make international order possible.
Moving on to the second rebuttals. Now, legal justice.
The image of helicopters over Caracas is haunting, and I accept its force. But let's not let the drama obscure the legal and moral choices at stake. What we witnessed in January 2026 must be judged as a targeted, time-sensitive law enforcement measure aimed at stopping imminent transnational harm, not as an open-ended invasion. There are three concrete legal anchors that distinguish lawful action from lawless coercion. First, anticipatory self-defense protects a state when credible, imminent attacks on its nationals or vital interests can be attributed to state-enabled criminal networks. Necessity and proportionality are the checks that prevent abuse, requiring the least intrusive, effective means. Second, valid consent from a legitimately empowered Venezuelan authority would convert operations from unilateral force into cooperative enforcement. Consent matters because it preserves territorial integrity while enabling cross-border accountability. Third, criminal justice doctrines, extradition frameworks, universal jurisdiction for certain crimes, and multilateral cooperation against transnational organized crime create lawful pathways for arrest and transfer when delay would let killers act with impunity. My opponent insists the Charter's prohibition on force is absolute unless the Security Council acts. That principle is central, but it does not erase recognized exceptions like self-defense or genuine consent. The real line is whether an operation was necessary, proportionate, and narrowly tailored. They say imminence is missing. I ask, imminence of what? A diplomatic insult or a confirmed imminent shipment of lethal narcotics that will soon kill innocents abroad? If intelligence establishes the latter and no practicable alternative exists, inaction is not legality, it is complicity. They also challenge consent, suggesting any domestic approval from opposition actors is suspect. Fair point, which is why legal legitimacy turns on clear, demonstrable authorization from officials who can lawfully bind the state or from domestic institutions empowered to act when the sitting apparatus is corrupt. Where that clarity exists, cooperation is lawful. Where it does not, the burden is on the dissenting state to identify practicable non-force alternatives that would prevent imminent deaths. On separation of powers, the president's commander-in-chief responsibilities include defending the nation, but that constitutional authority does not negate the need for prompt congressional notification, judicial review, and immediate access to counsel and a fair trial for the detainee. That is how an extraordinary enforcement measure becomes accountable, by rapid handover to courts, transparent prosecutorial process, and independent oversight. Three themes tie this together: prevention of imminent harm, preservation of sovereignty through consent and legal process, and accountability rather than impunity. If we accept that territorial integrity cannot be a blanket shield for leaders who weaponize the state to export violence, then the question becomes not whether force was used, but whether it was constrained, necessary, proportional, and followed quickly by judicial proceedings. I will press next. What specific, practicable alternative would have interdicted those shipments and secured the evidence without the operation? And how would that alternative have saved lives in the intervening hours and days?
Now illegal invasion.
The core question we keep returning to is simple. Can a state erase the international rule that bars unilateral force against another state whenever it finds the result politically convenient? My opponent frames the capture as a narrow, necessary enforcement measure, but that framing collapses once we test it against three hard legal thresholds: legal authorization, factual imminence, and lawful domestic process, each of which the operation fails to meet. Start with the baseline rule. The UN Charter forbids the use of force against the territorial integrity or political independence of any state, except where the Security Council authorizes it or where a genuine right of self-defense exists under the Charter. That baseline is not a diplomatic suggestion. It is the linchpin of international order. Self-defense is tightly defined. It requires an actual or truly imminent armed attack, necessity because there were no practicable alternatives, and proportionality in response. Allegations about long-running narcotics networks or future shipments do not satisfy the immediacy and necessity tests. If every transnational crime could be converted into a pretext for cross-border seizures, the prohibition on force would be meaningless. On consent, the claim that some authorized Venezuelan actors permitted foreign forces must be tested against legitimacy and authority. Consent that is unclear, contested, or supplied by actors who do not control the territory cannot lawfully convert an invasion into cooperation. You cannot lawfully abduct a sitting head of state because proxy actors claim to agree. The competence to consent matters. Domestically, the executive's duty to protect citizens does not erase separation of powers or establish statutory procedures. Emergency language cannot be used as a blank check to bypass extradition, mutual legal assistance, or congressional oversight. Skipping those processes undermines both the rule of law and constitutional checks on force. Practically, the consequences are foreseeable and dire: destabilizing Venezuela, exposing civilians to violence, inviting reciprocal abductions by rivals, and corroding the very norms that protect smaller states from great power coercion. Those harms are not speculative abstractions. They are the predictable result of normalizing extraterritorial seizures. My opponent asks, rhetorically, whether justice requires waiting for diplomacy. The answer is not paralysis. It is fidelity to lawful alternatives that preserve legitimacy: coordinated interdiction, extradition efforts, multilateral prosecutions, and referrals to international tribunals. If accountability matters, it must proceed through legal channels, not by violating the Charter of International Order and the constitutional limits that constrain the use of force. For closing, insist on immediate, transparent inquiries, judicial review, and renewed commitment to lawful, multilateral mechanisms for prosecution and extradition. Short-term expediency cannot be allowed to rewrite the rules that keep interstate violence in check.
Finally, the closing statements from both sides. Now, legal justice.
What this debate has shown is that this was not lawlessness dressed as power. It was an attempt to enforce law where law had long been evaded. We've laid out three linked pillars. First, narrow legal authorizations for extraterritorial force exist: self-defense against imminent transnational threats, consent from legitimate Venezuelan authorities, or treaty-based mandates, and the operation was framed to meet those constraints. Second, this was criminal accountability, not conquest. When a head of state is credibly implicated in transnational crimes that kill and destabilize, states may act with necessity and proportionality to prevent further harm and secure evidence for prosecution. Third, domestic executive authority can lawfully authorize such operations while preserving detainee rights and judicial process. Their strongest objection is sovereignty. Ours is that sovereignty isn't a shield for impunity. If we insist on strict limits, necessity, proportionality, and prompt access to courts, we prevent abuse and protect order. Holding powerful actors to account strengthens rather than weakens the rule of law.
Now, illegal invasion.
Think back to January 2026, helicopters over Caracas, a foreign operation seizing a sitting head of state. That image matters because law exists precisely to prevent power from deciding who may be kidnapped or killed across borders. The UN Charter's prohibition on the use of force and the bedrock principle of sovereignty are not optional when the result looks politically convenient. There was no Security Council authorization, no credible imminent attack to satisfy self-defense, no lawful consent from a legitimate Venezuelan government, and no demonstrated necessity or proportionality. Domestically, the executive moved without congressional authorization and bypassed extradition and mutual legal assistance channels. Claims that this was justified as self-defense or crime fighting are speculative pretexts, not legal exceptions. The practical consequences are stark: destabilization, civilian harm, erosion of the rules-based order, and U.S. moral standing. The lawful path is clear: pursue courts, extradition, international fora, and proper congressional oversight. If we abandon law for expedience, we lose the very authority to demand law from others.